if an officer stops you, interacts with you for some reason, and you are engaging in lawful constitutional carry, despite the fact that this law is on the books saying that you can't do that, they can't enforce it. It's unconstitutional.
We are the Armed Attorneys. Today we're talking about some critical updates when it comes to rights of 18, 19, and 20-year-olds to carry in the state of Texas. Now, this could have wide-reaching implications because we see the application of the New York State Rifle and Pistol Association v. Bruin case. We get to see where the rubber meets the road and how it could actually play out in other states. But before we begin, show your support for the Second Amendment by hitting that like button. And this is, I won't say it's like breaking news, because we had, the Fifth Circuit Court of Appeals dismiss basically an appeal from the state of Texas saying, hey, we have this district court say 18, 19, 20-year-olds, they have to be able to carry under constitutional or permitless carry. You have to give them licenses to carry. The Fifth Circuit Court of Appeals dismissed the appeal on December the 21st, but now we start to see the communications coming out of the DPS and how it actually will play out. And so now I think is a good time to talk.
Correct. Because, it's not breaking right now, but it's definitely like Ron Paul gif, it's happening, right? Like that's where we're at. So what we have is, we have this case in which Judge Pittman out of the Northern District of Texas said it violates Bruin. It violates the Second Amendment, the constitutional rights of 18, 19, 20-year-olds to not allow them an avenue for carrying a handgun in public to protect themselves. And he sort of left that a little bit ambiguous, right? Whether that avenue be licensing, whether it be constitutional carry. State of Texas appealed and said, we disagree. We would like to control 18, 19, 20-year-olds in their carry in public. And subsequently, the state of Texas chose to withdraw its appeal. The Fifth Circuit has dismissed that appeal. And now we are left in the position in which there is a valid enforceable injunction from the Northern District of Texas, and the state of Texas is now contending with that. So what has the DPS done?
So we have kind of two different things here, because and remember when the court issued this wonderful opinion saying, hey, you got to let them constitutional carry, hey, you got to issue the licenses. They stayed themselves. They said, hey, this isn't going to go into effect until, for 30 days, or, if this case is appealed while the appeal is pending. It's been dismissed now. Now, the DPS has come out on two fronts and notified its officers and all law enforcement commissioned officers in the state of Texas, kind of two different things. I'll go over LTCs, and you can talk about constitutional carry, but what they transmitted to all the DPS personnel is, to all law enforcement personnel, a federal district court has ruled that the Texas Department of Public Safety can no longer prohibit otherwise eligible 18 to 20-year-olds from obtaining a license to carry. Texas DPS will therefore no longer deny applications solely on the basis that the applicant is 18 to 20 years old. Officers may come across a valid LTC that may be issued to an eligible individual under 21. As with any other LTC, these licenses can be validated using the TLIT system. They have a checker to make sure that these things, are valid.
And what's funny is I actually talked to a 20-year-old who called in with legal questions about just carrying. What was it, last week or the week before last?
Yeah.
And he said, hey, I didn't know any better. I applied for my license in Texas. I'm only 20. I don't fall into an exemption. And they sent it to me. And I just realized that I'm not 21. Like, he was like, is this legal? And at the time, we weren't sure that this was actually their policy. And I was like, hey, even if they messed up, it's yours now, right? I mean, that's
And so what the DPS, and that's what made it confusing, because this communication came out weeks after the court's decision. And so we see, it looks like they're kind of crossing their T's and dotting their I's here. But effectively what this means for folks applying for a Texas license to carry a handgun, we look at our eligibility criteria under Texas Government Code 411.172, A subsection 2, where it says you got to be 21. Basically, they're treating that number now as the number 18. And so long as you meet all the other criteria, you would be qualified. Now, this doesn't just stop with licenses, and I encourage my clients, get your license, keep your license.
There's a lot of good reasons for that.
But it also expands to constitutional or permitless carry.
That it does. A very similar communication came out from the DPS about a month ago, really. This one came out first. And in relevant part, it reads, commissioned officers may not enforce Texas Penal Code 4602A12A against 18 to 20-year-olds based on age. That's constitutional carry, by the way, in case you're wondering what that string of numbers and letters is. This directive has immediate and permanent effect unless countermanded by the Office of General Counsel through your chain of command, which it will not be. Let's be clear. So, That's great. I mean, what that means in effect is not only is the DPS issuing licenses to 18, 19, and 20-year-olds, who I agree wholeheartedly with Richard, assuming that you have the ability, both financially and with your time, to jump through those hoops, do it. But if you don't, and you are carrying under constitutional carry and you qualify, right? Because remember, there are other things to think about. For example, if you were convicted of misdemeanor deadly conduct 6 months ago, Richard, are you allowed to constitutional carry?
No.
No. So you must otherwise qualify. But if you otherwise qualify and you're 18, 19, 20 years old, the DPS has directed all of its officers, and the same should apply throughout the state of Texas, even though there is not this formal directive that we've seen circulating, that if an officer stops you, interacts with you for some reason, and you are engaging in lawful constitutional carry, despite the fact that this law is on the books saying that you can't do that, they can't enforce it. It's unconstitutional.
And as Emily said, this directive came from the DPS, and, unlike some states where maybe the entire state police force is controlled by a single entity, we have lots of jurisdictions here in the state of Texas. So it wouldn't surprise me if we saw folks arrested after this appeal was dismissed for violating this provisional law. Do they have legal grounds or maybe some good feet to stand on at this point going forward? I do think so.
100%.
Yeah, so
there should not be any convictions from those arrests.
No, there absolutely shouldn't. Now, there are a whole host of issues that accompany, 18, 19, and 20-year-olds carrying just in general. And, we're not really going to go through all those things, but just keep in mind all the other laws in the state of Texas still in place. This was a very narrowly tailored injunction. It doesn't change too much other than just these age brackets, so you got to be careful.
Right. And remember, and stay tuned, because Texas is officially in its legislative session right now. So if you are an 18, 19, or 20-year-old who is currently getting an LTC or engaging in carry, I'd say if you're getting your LTC, you don't think have anything to worry about going forward at all. But if you're just engaging in constitutional carry, I'd say be careful, because I would not be surprised if we saw bills this session that were essentially trying to push them out of constitutional carry by giving them another avenue, right, to carry. So I would say be wary. We'll see what happens in Texas this session, because the legislature can still muck around with it.
But that's why it's so important. If you want to stay on top of these types of issues, obviously we're here in the state of Texas. We watch this stuff closely. Make sure to like, subscribe, and help us fight the anti-2A algorithm by sharing this video.
And always question and comment below. Again, this was a very frequently asked question, so here we are. We read your comments. We try to address the things that you want to hear about. So until next time, we're the Arms Attorneys.